Thank you all so much for coming. I'm State Senator John Morse. And today, we're turning up the heat on cold cases. Yesterday, the law was we collected DNA upon felony conviction. Today, 11 hours ago or so, 12 hours now actually, we changed that law to collect it upon felony arrest. And this is so critically important because there are so many times when people commit heinous, horrible crimes and we don't know who they are. And then they commit a felony, which is not a good thing ever, but a lesser degree felony. We know who they are, we arrest them for that, we have them in our custody. But eventually, since we don't know about the first crime, as that case processes its way through the system, they end up pleading to a misdemeanor, and they're never convicted of a felony. We never get their DNA and never can connect them back to what they've done. This law changes that, and now we'll collect the DNA upon their arrest. So a serial rapist and murderer who's arrested for check forgery at a felony level will now have his or her DNA extracted so that we can match that to already existing cases. This law began because of Katie Sepage's circumstance. And in that circumstance, she was kidnapped, raped, brutally murdered, set on fire. The man that did that to her was actually in custody just a couple months later on a separate felony charge, but we didn't know he'd committed the big crime. All this occurred in New Mexico. So he was released on the second crime and went on to commit a third crime, which was another rape, murder, homicide, which actually happened in Mexico, and he hasn't been convicted of it to this day, but it appears very much that he did it. And then after he was convicted eventually of the felony back here, then he was connected to Katie's case. But in the meantime, someone else died, and he was on the loose for about an extra year or so when he didn't need to be because he could have already been convicted of this case. So Katie's mother, Jayanne Sepich, has worked throughout the country to get this law passed. And when we passed it here in Colorado, we were the 18th state to do so. It actually went into effect July 1st, 2009. From a large perspective, we started collecting the fees. We collect a $2.50 fee from everyone that's convicted of a felony, a misdemeanor, or even a traffic offense or traffic infraction to fund this. It'll cost us about $1 million a year to do it. And we needed this time from July 1st, 2009 until now to collect enough fees to actually be able to implement it because the state provides the collection kits, which are about $5, a little over $5 a piece. So we needed to accumulate enough money to be able to do this. That's why the start date to actually collect DNA was deferred until today. So with that brief introduction, next we're going to hear from various members of the law enforcement community, much of it here in Colorado Springs, some of it obviously statewide, to let you know what's going on with what we're actually doing here, and then we'll wrap up and answer questions. We'll hear from the Colorado Springs Police Department Chief of Police Rick Myers, then we'll hear from District Attorney Dan May, then we'll hear from CBI Director Ron Sloan, used to be the police chief in Arvada prior to taking over CBI, and then we'll hear from Commander Mitch Lincoln, who is with the El Paso County Sheriff's Office, and this collection is actually done at the jail, so he'll be able to brief us on that, and I will probably jump in between here, make sure everybody gets a proper introduction, but next, please welcome the Colorado Springs Police Chief, Rick Myers. Chief, thank you for being here.
Thank you, Senator Morse. It's certainly our pleasure and honor to host you all today for the press conference. This is a big day, and this is a day for crime victims. You know, that's really what we're in the business for in policing, is to address the needs and concerns of crime victims, and particularly the victims of violent crimes. And that's where this new law is really going to make a difference, because it will help us get repeat offenders off the streets sooner and before they can commit additional crimes. And part of helping victims come back to feeling whole is holding offenders to justice, and particularly in the case of violent crimes. You know, the analogy I like to use is, for my entire 33-year career in policing, we've always collected fingerprints at time of arrest. We haven't waited until time of conviction. So why wouldn't we want to collect DNA samples for violent felons at the time of arrest like we do fingerprints? DNA is just a much more extraordinary and robust way of identifying the uniqueness of an offender, much like fingerprinting. And I think it's important to keep in mind that this law really is designed to target repeat offenders. The person who makes a significant mistake once in their life and is arrested for a felony and has their DNA collected, and they're able to turn their life around and lead a productive life, has nothing to worry about this law, because their DNA isn't going to show up at a crime scene. It's not going to show up at a violent rape or a homicide scene. This law is to help us identify and apprehend more quickly violent offenders who are repeat offenders. And that's really the bread and butter of what major crime investigation is about. So we're grateful to the legislature of Colorado for making this happen. And we're grateful to be one of the participants in the system, the criminal justice system, that can work with the courts and the crime labs and CBI for managing this whole process. And hopefully, in the not too distant future, we can have some more press conferences telling you about the number of hits we're getting and the number of arrests we're able to make because of this law. Thank you.
And next, very quickly, 4th Judicial District, District Attorney Dan May.
First of all, I do want to thank Senator John Morse for being the sponsor of this bill and carrying this bill. It really is refreshing to go up to the legislature and meet a legislator, or senator in this case, who knows criminal law. He started in the Colorado Springs Police Department. He was chief of police of the Fountain Police Department. So when you go up and discuss what DNA means, what it means to investigation, we really appreciate you being up there and understanding the issues. I'll tell you, as you look at the history of this, this is a huge step forward in DNA. As I've watched this through my career, I remember 20 years ago when we took the very first DNA case to trial. And here in this jurisdiction, we were trying to convince courts these were important in criminal cases. This isn't just science used in universities. And we had to bring in experts worldwide to show that this was a legitimate science, that it was a valid science and could be relied on by jurors. And we had long battles in court in motion hearings, hours long, with experts testifying to that. Prosecutors have always been at the forefront of trying to get DNA into court. We won that case, the very first one on the books with DNA. As we went further along, we've had huge changes in the science. The science is much better today, can do much smaller samples, is much better testing, and they're developing a huge database. The next step forward for us was when the legislature carried a law that said if you charge someone in a DNA case, there is no statute of limitations. Otherwise, in a normal rape or normal burglary or whatever normal robbery case, if we had DNA and we caught them 10 years later, the statute of limitations had run and they got away with their crime. Well, the legislature passed a law saying that if you file the case with DNA, there is no statute of limitations. So we literally have some arrest warrants over with the court that say the people versus, and it gives their DNA. We have no idea who the person is, but it preserves our statute of limitations, and we can still prosecute that case. That was a huge step forward. And I'll tell you, we just recently, you reported on it in the news, Matthew Labonte. Was a case, it was a gruesome rape and brutal assault of a woman in 1995. When he was arrested on a totally unrelated felony, nonviolent offense, and taken into prison 3 years ago, for the first time we compared his DNA and realized this is the person who did that brutal rape. Huge step forward for us. This is another big step forward. Doing it on arrest is the right thing to do. That's when we do fingerprints. That's when we do mugshots. We always keep those records, and we can always go back to those if we get a fingerprint at a scene. We think this, again, will lead to a number of unsolved homicides and unsolved rape cases that will come from this being at the arrest stage. We do want to see further advances. Quite frankly, this statute has an expungement clause in it. And I know that when you go through the legislative process, you're doing a lot of compromises to get the right bill through. And we've talked about that, and we know you had